My name is Laurent Pech. I'm the head of the Law and Politics Department at the Middlesex University, London. And it's my pleasure tonight to give a lecture, rather a talk on the EU Charter and its scope of application. There is no such thing as a simple legal issue in EU law. So this provision did give legal binding effect to the EU Charter, but because of the reluctance of some national governments, the text of the EU Charter is not reproduced in the main body of the EU treaties, mostly due to the UK government's reluctance to see the Bill of Rights included in the main body of the treaties. So essentially tonight, the main issue was to give a broad overview of the EU legal framework as far as respect for human rights is concerned. Now, it's not an easy topic because the legal framework has been subject to a number of amendments since the establishment of the EU in the 1950s. Tonight the topic was essentially the Lisbon Treaty and the amendments he has brought about. The key issues tonight are essentially, the first issue is the EU Charter of Fundamental Rights and then EU accession to the ECHR. To summarize perhaps my main points, as regards the EU Charter of Fundamental Rights, the most tricky issue is to know when a litigant can rely on the EU Charter before domestic courts, before national courts. Long story short, essentially you have to show to the national court that the dispute is governed by EU law. That is not easy to do so in practice. It's very rare for the Court of Justice on appeal, and actually turning down the first ruling. The Court of Justice sided with the applicant and annulled the EU regulation to the extent that it applied to the applicant. The EU regulation freezing the financial assets of the applicant was found to have breached a number of human rights. Breached the applicant's human rights. You have a summary, essentially his rights of defense, his right to effective judicial review, his right to property were all breached according to the Court of Justice. And the EU Charter, even though this case took place before the Lisbon Treaty, the provisions of the EU Charter were mentioned in the ruling as well, so just to add to the authority of the ruling.
My main aim, I suppose, in my career has been an attempt to show how EU law can be used to win cases before national courts. It's sometimes been a bit of an uphill struggle, but because there does require to be an element of education, both of one's own clients, one's opponents, but also of the judges. But EU law potentially is a trump card because of the notion of the primacy of EU law, which means that if national law is incompatible with applicable EU law, the EU law wins and the national law is disapplied. So it's a very powerful tool.
Provision of the Charter says that Title IV cannot create justiciable rights. If you look at the Charter, what is Title IV headed? Strangely, it's called Solidarity. It's a great thing for Poland to opt out of, but in the post-communist world, solidarity is no longer the buzzword that it was in Poland before. The solidarity are various employment-related rights, trade union-related rights, which the Polish government of the time decided was no longer in line with the kind of vision for Poland, that sort of new Europe, to use an old phrase.
This is a great opportunity to, as part of that notion of the educating function, to let practicing lawyers know from my own experience how EU law can actually be useful for them, and how also to counter possible bad EU law points which might be raised against them. So it's really terribly important, given that EU law is complex, is changing, and that it is a new way of understanding human rights, I think, in the UK, particularly at this time of controversy as to whether or not the Human Rights Act will continue in its form. We still have human rights through the medium of EU law, and that will apply no matter whether the Human Rights Act is applied or repealed.